Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is Where is the Enforcement? Assessing the rigor and effectiveness of U.S. merger enforcement. In many ways, for a long time, merger review has basically followed the same playbook. The question we want to ask ourselves from time to time is, how effective is it really? Recently, we've heard some pretty loud criticism that in certain industries, that the tech industry being the primary one, a few key players have gotten to be too large. And one reason for that, critics have said, is that prior mergers that should have been challenged weren't. Some critics say, in fact, that merger enforcement is too lax and that markets suffer as a result. We're not just hearing that in the United States. The chief economist for the United Kingdom, CMA, had a similar statement within the past, recently. So today what we're going to do is we're going to talk to a leading expert who has done a detailed study, and what he found on the effectiveness of merger enforcement may surprise you. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Anora, what are we doing today?
Well, today we're going to discuss how to improve the U.S. merger enforcement by just having the agencies enforce their existing horizontal merger guidelines. I just want to note that our show, our Curious Amalgam, have covered the 2020 vertical merger guidelines separately, but that's not the focus of today.
Okay. So why is merger enforcement the topic we're going to be talking today? Why is that important?
Well, many of the public discourse, in my observation, on the U.S. merger policy and enforcement has been focusing on recommending changes through drastic legislative moves and maybe scrapping the consumer welfare standard entirely. However, I observed that there is perhaps an underappreciated perspective that the U.S. merger enforcement can be improved by just having the agencies committed and empowered to make use of their existing tools, primarily the agency's own current horizontal merger guidelines.
And what are we hoping to learn?
Well, we're hoping to first take a brief survey of the weaknesses of the current U.S. merger enforcement as observed by some scholars, and then we are going to focus on the role of the merger guidelines as tools available to the agencies. And then after walking through that, we're going to go into a little depth on the specific areas that the agencies can improve their practice by enforce in accordance with their merger guidelines.
Who's our guest today? Well,
our guest today, Professor John Kwoka, is an economist focusing his research on industrial organization, antitrust, and regulatory economics. Well known within the circle of antitrusters, Professor Kwoka has recently done some impressively comprehensive and broad research on the effectiveness of the U.S. merger policy and enforcement, including two such books, I think, published respectively in 2015 and 2020. Oh, personally, I just want to drop note that I've known Professor Kwoka through reading his books while in law school. So I might have some questions that I have since then, and I feel privileged that I get to ask all of those, not all of some of those today.
Awesome. All right. Well, let's bring in our guest. John Kwoka, welcome to the program.
Thank you, John. And Anora, it's a pleasure to be with you today.
Hi, Professor Kwoka. I would start just by basically asking you to give us an introduction to some of your recent work. And is it fair to say that you have, through some meta-analysis or some works that's comprehensive and broad, that concluded that the merger enforcement has gradually diminished over time in the United States?
That's a fair summary, Anora. What I had done in my 2015 book was to compile some new data on mergers and enforcement over the past 25 or 30 years in the U.S. and to look at how that has changed. You mentioned merger studies and merger retrospectives. Merger retrospectives, as many of your listeners know, of course, are careful economic studies of the outcomes of actual mergers, controlling for other possible influences so that one can't isolate the effect of a merger, for example, on price. It turned out there were lots of these in the literature, more than I think most people realize, and I gathered them all and conducted what's called a meta-analysis. So a meta-analysis is a method for summarizing evidence from lots of parallel studies so as to be able to extract what they generally show in a statistically valid way. And what they showed is that of all of these carefully studied mergers, that nearly 80% of them ended up resulting in price increases. And again, that was after controlling for all other influences, say cost or anything else, so that the average effect should have been zero. That is to say, if they had zeroed out both positive and negative effects. Some might be a little bit above and some might be a little bit below, but they should have averaged out to zero. And so 80% of them, in fact, resulted in price increases, and the increases were not small. They were on the order of 9 or 10%. So this was a major finding, and kind of a heads up for many people who thought that mergers were harmless or even beneficial. This is, of course, a very old debate in economics and antitrust law. But what this study showed is that based on actual studies of individual case experiences, dozens and dozens of these over quite a number of industries, that there was really cause for concern that the agencies, as I concluded, simply had not set the line right and not drawn the enforcement line in the right place. So that was a 2015 study. And my more recent book... Please go ahead.
I'm sorry. Just so that our audience have some context. So, what kind of time span are we looking at? These merger retrospectives that you have studied, are they spanning over 4 decades, 2 decades, or just more recently?
So they ranged over time. The earliest ones were done in the late 1980s, and then they ranged over a period of about 25 years up through the mid to late 2000s.
Okay.
So they did not include the most recent ones, partly because a merger, for example, that might have been done in the last year or two would not be a good candidate because you need a number, 2, 3, 4 post-merger years in order to draw a comparison to pre-merger, say, price levels.
And then maybe let's dissect the criticism of the merger policy and the merger enforcement a little bit. So I think your more recent book, the 2020 book, is focusing largely on the policy improvement that could be taken. And then are there other than the policy level discussion, are there any things more specific about the enforcement that's poignant in your view?
Yeah, so you had mentioned, Anora, that there's a great deal of action and suggestions, proposals for radically reforming antitrust. And my perspective on this is that some of those may be necessary, but before we get to those, a good first and necessary step would be to strengthen enforcement on the laws and judicial precedents that we have. And I believe that had we done so in the past 20 years, 10 years, 25 years, whatever it may be, that a great deal of the concern over rising concentration, mergers, and other structural changes in lots of markets in the U.S., a lot of that concern would have been blunted, which is to say that there may be some legislative changes that are necessary, but I think the place to begin is with improvements in strengthening actual enforcement. So, and one reason why I believe that is that, after all, it's not been new permissive laws that have weakened antitrust. Rather, it's simply been agency enforcement practices that have led to the erosion of merger standards. And so it seems, by the logic of that, is that different enforcement practices would ratchet that back and get us back on track. Now, it wouldn't accomplish everything. I think there are places where new legislation may be necessary. And it also requires, I think, dealing with the fact that the judiciary has become increasingly skeptical, in some instances hostile to agency challenges to mergers and other things as well. So there are a number of specific places that my current book, the 2020 book, a number of specific places where I think simple enforcement changes would go far toward addressing and rebalancing the erosion of merger standards.
Yeah, so from reading the book, I observed that you have recommended as many as 40 specific policy recommendations in 15 different areas. Maybe you can highlight a few of that, and then just so that our listeners would have a sense that what are those specific policy recommendations are.
So there are, as you say, a long list of policy recommendations that I have in the book. They're an effort, I think, to describe how sweeping are the limitations and weaknesses of current policy. The sheer number of them, I think, to some degree was surprising to me because there's a lot of discussion about dealing with specific issues. But in fact, the limitations and needs, I think, of current policy are really very widespread. And so what I offer is not what I offer there is to remind people that making one or two changes or improvements is not sufficient. This is not a buffet of alternatives. It really is a kind of need to deal much more comprehensively with the limitations of antitrust. So I suggest, for example, that the agency should return to a stricter enforcement of a structural presumption. I argue that the merger guidelines should be strictly enforced because, in fact, practice has deviated significantly from the thresholds. I argue that mergers that involve the elimination of potential competitors need to be dealt with much more substantially, and I think that's a place where mergers in the tech sector would come under a broader review or mandate by the agencies. And I recommend that the agencies be much more limited in their use of remedies, in particular conduct or behavioral remedies, which my research and that I think of others have shown to be largely ineffective. So that's 5 or 6 ways. There are some details on each of those and more in the book. But those are the ways in which current policy, in my view, could be strengthened without the need for sweeping away the apparatus and framework and legal standards and economic approaches to merger enforcement. These are within the purview, within the agency's discretion, and I think in the right hands, much could be done to strengthen merger control policy along these lines.
Right. And we are going to dive a little deeper into the structural presumption discussion. But before that, perhaps I'll bet our listeners would benefit from hearing you. What's the overall goal for your 2020 book? And as a follow-up to your 2015 study of the merger enforcement and quote unquote weaknesses. So what's quote unquote your agenda here? And if this book would achieve what you can do, I guess we're going to see broad policy reform. But what if it doesn't? Are you going to have a third book?
Well, after writing the 2015 book, I vowed not to ever write another book. It was sufficiently painful experience that it took quite a while for that to wear off or for me to forget it sufficiently. But I also, in all seriousness, was prompted to do that because the 2015 book really was a retrospective. It looked backwards on policy to see what it had accomplished and what it had not accomplished, looking at data on enforcement practices, on mergers, and used, as I said, a number of data sources that had not been tapped before. And so, but it was truly a retrospective. The 2020 book is forward-looking. It says, based on my work and certainly that of others, what sort of changes to merger policy are now well justified by the economics and by a review of weaknesses and failures of the past. And so a number of people, after I wrote and spoke at length in lots of different places about my findings in the first book, started to ask what specific recommendations I would have, or would I have for strengthening merger policy. And more by accident than design, the book grew out of those discussions, which I think emerged naturally from what the 2015 book revealed. And so there are some of these proposals in the current book are more radical and some are more modest. A number have found their way into current discussion in antitrust circles and even in Congress. And so, some of them are well within our grasp. Others, I think, are more ambitious. But again, I think all of them need to be considered.
Right. And as I previewed that we're going to, for the purpose of today, we're going to focus on the merger guidelines. And then, so for listeners who might not be familiar, briefly, perhaps, Professor Kwoka, you can summarize what for you as an economist, that what do you see the design the role for the merger guidelines? What kind of purposes should the guidelines be serving? Are they more of informing the business community what the agencies are actually doing, or are they, supposed to set out a set of standard and perhaps ideal practice guidelines for the agencies?
So the guidelines are quite important, constitute quite an important document. They have existed since 1968 and have been modified greatly in 1982 and again in 2010. And you're right, there are kind of two possible ways of looking at them. One is that they set out agency practice, analytical methodologies and approaches, and the other is to inform the business community how the agency will evaluate any specific merger. Now, I think in the early versions of the guidelines, there wasn't much daylight between those two purposes, but I think more recently, certainly with the 2010 guidelines, which are now, of course, 10 years old, but represented a substantial change. The guidelines really are more a description of what the agency does than they are a formulaic way for the business community to anticipate how their prospective merger will be evaluated, because they are very detailed. They're written to explain very much the way that the agencies internally examine and evaluate mergers using the best contemporaneous economic methods and models and data. And that's all good, but an initial comment, a frequent comment when they were released is that, well, this says that everything kind of matters. And that's not much help to the business community in anticipating how their own particular merger might be evaluated. Of course, matters have that's been changed, that's improved over time, but there's a great deal in the guidelines that remain, I think, more descriptive of what the agencies do than anything else. So the guidelines have changed over time because they've become more sophisticated and more consistent with economic understanding. It's also true, and my books note this, is that each successive version has weakened or loosened the standards for what constitutes an anti-competitive merger. And and I can explain that in a moment if you wish, but the point is that in loosening the standards, that flies in the face of the evidence I've just described, which is to say that excuse me, that the agency's practice has allowed a substantial majority of mergers to go through, even though a substantial majority has proven to be anti-competitive by virtue of significant price increases. So by loosening the standards, it simply allowed more mergers to go through, and they have resulted in harm to consumers and to competition.
Yeah, Professor Kwoka, that's a really interesting perspective on the horizontal merger guidelines. Maybe let's talk a little bit about some of the specific ways for the agencies to enhance performance in the context of the horizontal merger guidelines. And let's start with presumption of likely market power. What do you think? What are your thoughts around how the guidelines treat this presumption?
So a couple things here. One is that, as I mentioned, the standards for what constitutes a presumptively illegal or presumptively anti-competitive merger have changed over time. Let me give one graphic example. In the latest version, the 2010 guidelines, the concentration thresholds for what constitutes a presumptively anti-competitive merger were loosened. In the earlier guidelines, it said that any sizable merger in an industry with a HHI of 1,800 or larger would likely be challenged. HHI is, of course, the current standard method for measuring concentration. An HHI of 1,800 represents approximately 6 or 7 equal-sized firms. Not that we ever have exactly equal-sized firms. Anyway, in 2010, the threshold rose to 2,500, from 1,800 to 2,500. But here's what's really interesting, and I think has not been widely appreciated. At the same time, in 2010, the guidelines expanded what's usually called a safe harbor. Safe harbor is a low-end range of HHI below which any merger is likely okay because it's presumed not to raise any competitive concerns. Well, in 2010, the range for the safe harbor expanded all the way up to an HHI of 1,500, which is almost as high as the cutoff of 1,800 that previously had indicated a presumptively anti-competitive merger. So that's a dramatic change in the standards employed and the guidelines representation, and in what the courts are being told represents a safe harbor versus a presumptively anti-competitive merger. And other evidence that I reported in both my books kind of show that the agency's practice has in fact followed this, that they have approved more and more mergers, conducted fewer and fewer investigations, challenged fewer and fewer mergers, all the way down to the place where there's only 4 remaining significant competitors, whereas previously, with some frequency, certainly not all of them, but with some frequency, they used to challenge mergers that ended up with 5 or 6 or 7 firms. For us, this is agencies, the FTC's own data shows that over a 16-year period that they had basically withdrawn from the battleground of mergers in that mid to high range of concentration, and only challenged mergers that resulted in 4 or 3 or 2 remaining competitors. And even some of those, of course, now we've seen are getting approval.
Interesting.
So it's pretty clear that, like I say, the standards have changed, the practice has changed, and we're being told that these mergers are okay.
It's interesting because that probably, again, that's probably pretty strong evidence for your book, right? It's probably just a reflection of the reality that what used to be I'm repeating your point, but what used to be a presumptively illegal merger is now almost, getting pretty darn close to a presumptively legal merger is pretty close to being a presumptively legal merger. That's a sea change, and I guess it's a good illustration of the point you were trying to make more broadly.
Yeah, and you mentioned that actual practice. I mean, one of the curious things is that I've looked really hard for an explanation for why the standards in 2010 were changed, why the thresholds were raised to this high level for what constitutes a presumptively anti-competitive merger. And as you say, the Assistant Attorney General for Antitrust at the time said that, well, this brought policy. This was not new policy. It simply reflected agency practice. But my view is that if practice was deficient, formalizing that or essentially validated poor practice. And so that was hardly an explanation. It was really more a reflection of the fact that the agencies had ceased enforcement in a range that did constitute anti-competitive problems with some frequency. So there are many reasons, I think, that went into this. There certainly were ideological pressures, continuing importance and emphasis on free market economics. There was an increasing drumbeat of concern about so-called type 1 errors, the dangers of over-enforcement of challenging mergers that were benign or even pro-competitive. We can talk a little more about that too. And then too, there were advances in economics. And there were some paradoxes, I think, there, because some of the advances in economics did not strengthen policy. It made it, in some instances, easier for firms to justify mergers. So there's a whole set of reasons, I think, that contributed to the rather dramatic, or as you say, sea change that was embedded in the 2010 revision of the guidelines.
Yeah, Professor Kwoka, a lot of the defense side practitioners love to go to the agencies and tell us stories about efficiencies and ease of entry. What is your view on how the agencies should treat those arguments?
So I've been involved. I've worked at both agencies at different times, and I've done consulting for them and for the state AGs and others as well. And so I've seen a lot of a lot of merging parties' efforts to justify their consolidation through claims about efficiencies and entry. And I would say two things. I mean, one is that over time, the agencies, I think, while they deny this, I think have become increasingly receptive to arguments about efficiencies and other benefits, no longer simply cost-saving efficiencies, but even more nebulous claims about improvements in quality or innovation somewhere down the line or some other benefit that's even harder to quantify. These are hard to perhaps to prove, but they're also hard to disprove. And so the agencies are in a asymmetric position, as economists would like to describe it, in trying to evaluate these. The agencies don't have the inside information or the business acumen or operational expertise to fully evaluate these claims. And so I think, the merging parties have little reason not to offer up lots of claims and to see which of them survive, in the hope that some part of it will represent an offset to whatever competitive concerns there may be. So once upon a time, the merger guidelines used to say that claims of efficiencies would only be entertained if they were of extraordinary size and significance. What's happened over time is that every set of merging parties makes such claims now. And I think one of the changes that would be helpful to the agencies would be to enforce a tougher standard, to again claim that routine small efficiencies are to be expected. Significant claims should only be made in extraordinary circumstances and have to be supported by better evidence than the sort of thing that presently the agencies get from the merging parties. With regard to entry, here too, I think the agencies have issued useful guidance as to what constitutes entry, the possibility of entry that counts. They have to be sufficiently large and certain and things of that sort. And all of that's quite helpful in pinpointing what's going on. But again, claims of easy entry are quite easy to make. And it turns out that when claims are made for ease of entry, these almost always, if they survive agency scrutiny, these almost always represent a decisive argument. Agency data shows that whenever claims of ease of entry are accepted by the agency, that the merger is approved uniformly. So I think these are tough calls for the agencies as well. But it, I think, represents another place where there's sort of excessive deference to claims on the part of merging parties. And that, too, has contributed to weakening of merger enforcement.
Professor Kwoka, I want to shift gears just slightly because it's to a topic that I'm very interested in, and that's potential competition. And as I kind of look out at the landscape, a lot of the concerns we're hearing about and some of the cutting edge issues, I think, are really driven by potential competition. Our community is very interested in the discussions about killer acquisitions, for example. Likewise, if you look back at some of the prior mergers that were done in the tech space, I think that there were concerns that potential competition may have been snuffed out by the, but without having been maybe as thoroughly reviewed as possible. That's what some of the critics say. How would you approach potential competition?
So I would second your views and opinion on this for sure. Potential competition, I think, is an area that has languished in current enforcement and recent enforcement. But this is a good illustration of a place where new legislation may be required. A rather old Supreme Court decision, Marine Bank Corporation in the early 60s, I believe, established pretty tough criteria for what an agency had to prove in order to challenge successfully a merger that eliminated a potential competitor. So that's a problem. That's a reason why I think the agencies have shied away from this. But again, the agencies need to redouble their efforts, at least to try to persuade judiciary at the margin that some cases along these lines will meet the standard. And all at the same time, I think, to deal with the legislative necessity to modify the judicial precedent. So the problem here is, of course, that if we focus strictly, and this, of course, is an exaggeration, on mergers between incumbents, we leave any incumbent to vacuum up, potential competitors that are in the surrounding space. And as a result, that relaxes the competitive constraint on the incumbent, and it also eliminates a firm that might evolve into a much more significant competitor down the road. And there's a good deal of evidence that that's happening. The number of publicly listed firms in the U.S. has declined precipitously over time. And a number of people trace some of that to the weakening standard by which incumbents can consolidate, acquire, threatening outside firms. And as a result, you eliminate potential threats to their entrenched positions. The tech companies are Exhibit A, but they're by no means the only case. The 5 major tech companies in the U.S. have acquired approximately 700 companies over the past 20 years. Now, to be sure, lots of them, are quite harmless for various reasons, but they certainly include a number, not just Instagram and WhatsApp, but a number of others that I list in my book that represent mergers and acquisitions that at the time may or may not have been fully appreciated for their competitive potential, but in retrospect look pretty problematic for the way that they allowed the tech sector to insulate itself from threats. Now, I've gone back to the case evidence on some of those. It's interesting reading. The question, of course, is not so much with hindsight what somebody should have done, but what they knew at the time or should have known at the time to alert them to this sort of potential. And there are cases where that potential was recognized by some parties at the time, the press, analysts, economists, legal scholars, but not fully appreciated by the agencies. And I think that, too, represents an indictment of the way that the agencies have shied away from some of these cases. So this is a huge area of concern. killer acquisitions, nascent competitors, and the older name for this of potential competition really requires, I think, a great deal more attention.
We could talk about this all day. Fascinating stuff. One last question, then let's shift gears a little bit. Can you tell us, folks may be interested in learning more and reading your book. Can you tell us a little bit about where they might be able to find it and how they can get a copy?
Sure. The book is called Controlling Mergers and Market Power, an Agenda for Reviving Antitrust in America. A rather grandiose title, I might add, but it's available from CPI, Competition Policy International Publishing, and it's also available, as is everything, on you-know-what platform, tech company.
All right, and with that, Professor Kwoka, let's shift gears a little bit. Can you tell us something about yourself that people who only know you professionally wouldn't know, something that's interesting or unique?
Sure. So let's see. So actually, one thing I might offer up in that spirit is the following. So I've gotten over the years a couple, notifications or awards for things I've done. But one of those that I think was the most unexpected, but has a prominent place on the office of the wall of my office, is being named by my Department of Economics at Northeastern University as Woodworker of the Year. Yes, that's right, Woodworker of the Year. So I do woodworking. And several years ago in the department, we had a kind of a secondary conference room that had some old desks and tables in it, and the laminate around the edge of the table that started to come off. And of course, we called facilities, and they came and they used something or other on it, and it promptly started to delaminate again. So I walked into my chair one day in Sherman and said, if you want me to take care of this, I'll be happy to do it. And he was kind of surprised, but after I explained, I told him what I was proposing to do. So the following week, I marched in with my bar clamps, my glue, my brushes, and all of the equipment, and dragged a couple of graduate students in to do some manual labor and managed to glue and laminate the things. And for that, I got named as the Woodworker of the Year by the Economics Department at Northeastern.
That's a pretty impressive recognition. Has anybody been named Woodworker of the Year since?
No. See, that's the thing which, you might view as even more significant, or even putting this in its proper perspective. That's the one and only time anyone has been named Woodworker of the Year by the Department of Economics. Make of that what you wish. Do
you own a table saw?
Do I own one? Yes, I do.
Okay. Well, then you're qualified. All right. Professor Kwoka, do you have any advice for law students, younger economists, who might want to do what you do?
So I'm reluctant to give advice, but let me offer an observation and see what implications it has. My observation is that there really are numerous important and unanswered questions in economics and antitrust economics and antitrust law. In fact, there are many unasked questions, much less unanswered. And all of these represent, I suppose, both cautions and opportunities. There are cautions not to believe that there are simple universal answers, but there are opportunities to do more economics and legal research to fill in kind of important gaps in our understanding. So the implication of that, this now sounds a lot like advice, is to be skeptical about what one hears, particularly any claim about universal or widespread application of some simple theorem. Be skeptical about that. Be careful in what one relies on, and certainly in how you rely on it, how one portrays it to clients or agencies or whatever. And lastly, be curious about what remains to be investigated. There are just lots of interesting and important questions out there that are, as I say, opportunities to make a difference in what we understand and how we apply our understanding.
Well, this is super helpful. Let's go to our final segment called The Curious Hat.
And now it's time for The Curious Hat.
Now, Professor Kwoka, I have an actual hat with me. We used to have people, we were doing this particular program remotely. We used to have people actually pull the questions out of a hat. Since we can't do that, we're not in the same place. I am wearing the hat. And what I'm going to do is ask you to choose a number between 1 and 25. And I will read the question that corresponds with that number.
Let's see. How about 18?
Question 18. What was your favorite course in college or law school or graduate school?
Well, let's see. I mean, I think this is a boring answer, but I think my favorite course, in fact, was industrial organization economics courses that I had at the University of Pennsylvania when I was there, partly because I had two incredibly distinguished professors teaching them. One was Al Phillips, and the other was Ollie Williamson. Ollie, of course, recently deceased, was a Nobel Prize winner, and it was exciting to be in the presence of both of them. And I think that they, more than anything, were the reasons why I decided to pursue what I have done.
Now let me ask this follow-up question. Were there any courses at your undergraduate or your graduate school that were what we used to call guts? A course that was known to be a relatively easy course. And if so, which, if any, of those courses did you take?
So let's see. Again, in grad school, there were a couple faculty members who shall go unnamed who were, I would say, sort of toward the end of their careers, and they offered courses that were widely viewed as gut courses. And so when one saw an otherwise bad semester coming up, one might take that. So I did take what purported to be a micro theory course that I think was a salvation of the rest of my curriculum that term. So I did that. I certainly opted for that where necessary. I also remember a stat and economics course taught by another very distinguished professor, Robert Summers, which course I passed. But then when I took the comprehensive exam in that, he told me that I had done worse than any other student he had seen in 10 years on the comprehensive exam course. So my record wasn't. My record had its ups and downs.
When I was a senior in my undergraduate, I took the course that had been aptly named Rocks for Jocks. And the thing that was really super unfair about it was they had a new professor, and it actually became a really hard geology course. I actually turned out kind of liking it, but it was really super unfair because it was not what I had signed up for. All right, Anora, how about you? What undergraduate class did you take that was known to be a gut?
I would not reveal that.
So you're saying you've never taken a gut class in your life?
I'm not saying that either.
I'm just trying to understand. You've never taken a class that was perceived to be easy.
That I might have, but I don't think that's a gut class.
Interesting. So name your class. Name your class that you think would appear to be a gut, but of course never was.
I took Chinese literature.
That sounds pretty hard to me.
Well, as a native speaker and someone who has been studying for the years, it's pretty easy.
Got it. So a gut is in the eye of the beholder. And with that, thank you for listening to us on Our Curious Amalgam, and we will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.